Is the Deputy Solicitor General at the Justice Department. Laurence Tribe is a professor of constitutional law at Harvard University. He joins us tonight from Boston. Mr. Roberts, why did that federal judge in Wichita not have the right to do what he did?
Well, first I think it's important to clarify what it is that we did and what we did not do. What we did not do is take a position supporting the activities of the Operation Rescue protesters. There's been some confusion about that, and I want it to be clear. In fact, what our U.S. Attorney out in Kansas said in a very firm statement was that everyone must comply with the court orders and that the U.S. Marshals, officers of the Department of Justice, would enforce the court's orders. That needs to be clear. Second, we filed a brief with the court, sending him a copy of a brief we filed in April in the Supreme Court in a related case. It didn't cause much of a commotion back then, explaining that the law under which the abortion clinic providers and patients were suing the demonstrators did not apply in this case. It did not give the federal court jurisdiction. The law is called the Ku Klux Klan Act of 1871, and that conveys a pretty good idea about what the law was intended to do. It was directed against people going out trying to interfere with the constitutional rights of blacks. The Supreme Court indicated in a 1971 decision that the law was limited in that way. It did not apply across the board to any kind of demonstration. It may or may not apply to demonstrations directed against women, but people who are against abortion are not discriminating against women. It's a different issue.
But I understand the first part of your answer is that and while this matter is under appeal, the U.S. Marshals will continue to enforce, from the Justice Department's point of view, the U.S. Marshals will continue to enforce Judge Kelly's ruling. Is that correct?
Absolutely. We think what the department did in Kansas has had a calming effect. It has made clear that the orders of the court must be obeyed, and it has made clear that the Marshals will enforce them. And
but at the same time saying, you do not believe the judge's rules are valid.
That's right. We're saying we're going to take the issue into the court and litigate it in that forum where it belongs. What our position is that the orders will be complied with and obeyed until they're reversed by another court. We're pursuing that avenue. We just think that the federal court is not the proper place for this case. It should be in state court, and it may be appropriate for the state court to issue an injunction against these activities. We take no position on that. Our position is simply that this is not within the federal court's jurisdiction. That's what we told the Supreme Court last April, and that's what we told the district court in this case.
Professor Tribe, is Mr. Roberts wrong?
I think Mr. Roberts is doing a pretty good job of making the government's position sound fairly reasonable, but I, this afternoon, reread what the government's submissions said, the very submissions that so dismayed me when I first saw them yesterday. And I'm afraid Mr. Roberts is not being really candid. It's true that the government is not positively approving of the blockade by Operation Rescue, but it's made no doubt at all about the fact that it is urging immediate lifting of this injunction on the ground that, just as Mr. Roberts said, they don't think that the Ku Klux Klan Act gives the federal courts any jurisdiction here. Now, if their position were accepted, that is, if this injunction were immediately lifted while the United States Supreme Court this fall considers the proper reading of that Ku Klux Klan Act, there is no doubt, and the judge found just this afternoon, that there would be the physical shutdown of that clinic, again, so labeled, has been interpreted by every court that's construed it in a much broader way. The words of that law are really much more general. They say that a conspiracy to obstruct any person or class of persons in the exercise of their equal federal rights is unlawful. And the 7 United States Courts of Appeals that have addressed the issue have all ruled that conspiracies aimed at women who seek to protect their rights to interstate travel and their rights to terminate a pregnancy, are covered here. Now, I just reread the government's brief in the Supreme Court, and it is astonishing to me what they say. On page 20 of that brief, they say that the right to have an abortion is not specific to one gender. Now, maybe there is a form of reasoning in which you can pretend that abortion has nothing to do with whether these are men or women. But even if that were true, in this case, it's been alleged, and the court specifically found, that men are allowed to enter the clinic. Male patients are allowed to enter. Male doctors are allowed to enter. It's only women who seek abortions who are not. Now, if the Justice Department is right that the act Congress passed does not apply in this situation, and I think they're wrong, and I think in the end they'll be held wrong, then we will have a very different and quite difficult situation. But in the meantime, to say, as Mr. Roberts says, and as the Attorney General has said, and as the President suggests, that the federal courts have no jurisdiction at all, even to issue an injunction to preserve the peace and avoid bloodshed in the interim, is to revert really to the law of the jungle.
What about that, Mr. Roberts?
Of course, that's not the case. The plaintiffs are free to repair to state court where they should have brought this case in the first place at any time, and if an injunction is appropriate, to secure an injunction from that court. The idea that we're going to be in a no-man's land when there's going to be mayhem and violence in Wichita is simply absurd. The state court is there to protect the rights of the abortion clinic providers and their patients according to law. That's where this case should have been brought in the first place. It's where they can bring it tonight if they want.
Let me ask you this, Mr. Roberts. Is this the position of the Justice Department is based on the fact that it is in concert with the anti-abortion protesters?
No, the administration position on abortion has nothing to do either with the case in Kansas, Kansas or with the other case pending in the Supreme Court. It is an interpretation of a very specific 1871 statute. Professor Tribe paraphrased the statute. What the Supreme Court has said about it, and I'll quote, is that it requires some racial or perhaps otherwise class-based, invidiously discriminatory animus behind the conspirators' action. The Operation Rescue protesters are against abortion. There's no doubt about that. They're not against women, so they don't fall within the terms of that statute. That's the position we took before the Supreme Court in April. That's what we advised the court in Kansas of yesterday. There's nothing new in that position. There was no uproar when we took the position in April, and frankly, I don't understand why it's being regarded as such a new departure at this time.
Professor Tribe, why is this regarded as such a big deal right now?
Well, first of all, there was something of an uproar when the Department of Justice took the position that obstructing the right of women to have abortions has nothing to do with the rights of women as a group. But the reason there's a special uproar now is that the suggestion that one shouldn't make a federal case out of it, just go to state court, is not nearly as simple as it sounds. This is exactly the argument about going to state court that was made in Little Rock, Arkansas in 1957 when federal courts were taking the locally unpopular position of enforcing desegregation orders, and when the argument was made that the federal courts had no business doing exactly that. It took a while, but President Eisenhower finally saw the light and exerted legal and moral leadership in saying that because federal rights were at stake, this did indeed belong in federal court.
You see any parallels?
The professor's analogy
Hold on just a moment. Let him respond to that, please, Professor Tribe.
The professor's analogy begs the question. We agree. It's the Ku Klux Klan Act of 1871. Of course it was designed to give federal courts jurisdiction over the types of activities in the civil rights movement that the professor mentioned. The issue is whether it applies to abortion demonstrators, and it doesn't.
Well, of course, all of the courts, Jim, all of the courts that have considered whether it is limited to black people or extends to women have rejected the government's rather narrow reading of the law. But that's really a distraction. Let me assume, just for the sake of argument, that the current and quite conservative Supreme Court might agree with the Justice Department's position down the line and might hold that the Ku Klux Klan Act does not apply. I don't believe that, but assume it for the moment. In the meantime, the proposition that the Operation Rescue people should have the freedom, as long as the elected state judges in Kansas and as long as the officials in Kansas who have been dragging their feet and not protecting the rights of the clinic, according to the allegations in this case, the proposition that in that circumstance, you just have to take your chances with the state courts in the meantime, really means that the federal court loses the most essential power to preserve the status quo while a case is pending.
And that
the
is
rule of
that's
law
the key.
would really collapse if the very issue in controversy, the issue of whether the federal courts in the end are properly interpreting this much more broadly written law than one aimed only at conspiracies designed to deal with racial issues.
What about that basic issue?
While that issue is being litigated,
right. Well, let's lay...
you can have mayhem.
I think Professor Tribe has hit on the basic philosophical difference here. As he's just indicated, he doesn't trust the state courts in our country to defend the rights of the citizens. He says you have to be in federal court or you're taking a chance. I think the Supreme Court has made clear, and our constitutional system is based on confidence that the state courts, the state Supreme Courts, with review in the United States Supreme Court, will defend our liberties. The case is as if you have a federal constitutional right to picket in front of the White House if you want. Now, if somebody comes along and doesn't like what he reads on your sign and punches you in the nose, that's not a federal offense. You can sue that person in state court for battery, and the local police can haul him off in jail for battery, but it's not a federal offense, even though he's interfering with what is a federally protected right.
We now, I think we now understand the two positions here. Just as a quickly, Mr. Roberts, as a procedural thing, it's now this whole issue now goes before the 10th Circuit Court of Appeals. Is that right? And when is a decision expected on that?
I don't know the
on the
answer to that.
On the Wichita case. It could take a while, right?
It could take.
In the meantime, Judge Kelly's order remains in effect, and the abortion clinics remain open by the U.S. Marshals?
The order remains in effect. It must be obeyed, and it will be enforced by the U.S. Marshals. Yes.
Jim, I really can't... Jim?
Right.
I can't let pass the suggestion that there's some general mistrust of state courts here. That's not the point. It's that when Congress, as here, has conferred general jurisdiction on federal courts to preserve the peace while they consider the meaning of a statute, you completely eviscerate the protective power of those courts by saying that people can take the law into their own hands.
All right. I hear you both. Thank you both very much for being with us.
Thank you.